Healthcare is too expensive. Employers are offsetting costs onto their employees. Who will make health benefits affordable for hardworking Americans and their families? You will. This is the Empowering Plans Podcast, a show dedicated to helping you once again emphasize the benefit in benefit plan. Now prepare to learn, plan, save, and protect with the FIA Group.
Hello, everyone. Welcome to another edition of the Empowering Plans Podcast. I'm your host for today, Brady Bizarro, and joining me is attorney Andrew Silverio. Say hello, Andrew.
Hello.
Awesome. Well, today, special topic for us as we approach the holiday season is specialty drugs and employer assistance programs, or patient assistance programs, as they're known. I think today is important to do sort of a reset and a refresher on what these programs are, why they're important, and what sort of latest battles going on both in court and sort of behind the scenes from a policy perspective are regarding these programs. There was a good article published just, in fact, yesterday on modernhealthcare.com, a good site that we use to get some insight into what's being discussed in healthcare circles more broadly. And the article was about how employers are using these patient assistance programs to offset their own costs. So highly encourage you guys to go out there and check out this article because it gives a good explainer. And so we wanted to today is talk about our thoughts on these programs and the ongoing lawsuit involving Johnson & Johnson and one particular vendor and why it's important. So the first thing to note here is that this article makes a good case for why it's really unfair that patients are placed in the middle of this battle, right, between drug manufacturers and employers. The article describes a couple with a daughter who has juvenile arthritis. She's taking a brand name drug called Humira, which many of you probably are familiar with, which according to GoodRx costs about $66,000 a year. So one of the more expensive drugs out there. And basically what this article details is how the husband has employer insurance, self-funded plan, and they utilize a copay accumulator program, which deems Humira to be non-essential as a drug. And in doing so, the vendor says that this bypasses the Affordable Care Act's out-of-pocket caps, right? So it allows more access to the patient assistance and higher dollar amounts than would otherwise be available. And so just taking a step back here and figuring out how this program has proliferated in this form, just remember that these patient assistance programs were meant by manufacturers as a way to make their medications more affordable because about 1 in 4 Americans can't afford their existing medications as is. So over the years, I would say going back to at least 2015, perhaps even before that, there's been more and more scrutiny placed on these programs. They're kind of being looked at as a way, in some people's view, as masking what are really unreasonable price increases by manufacturers. So they get the benefit of portraying these programs as sort of a charity. And there's even some tax benefit that they get as well. And so they can say, look, our drug may be very expensive, but we're offering patient assistance programs where they can apply, and if they qualify, they get massive reductions to their copays in the form of these coupon cards they can use at the pharmacy. And everyone's happy, right? It makes their drug more affordable for the patient, the employer's happy, allegedly, right? The manufacturer's happy. But of course, over time, people weren't so happy because what ended up happening is the trend was for people to be selecting specialty brand drugs over generic drugs in many cases when they were able to use patient assistance. So a quick example would be a scenario in which a specialty drug is costing, say, $10,000, a generic's available that costs $2,000. If the health plan here imposes a $500 copay for the brand drug and a $100 copay for the generic drug, you would think the person would select the generic version, right, with a cheaper copay. But if there's a patient assistance program available, which would offset the cost of the copay for the brand drug, say it's a $450 coupon, the patient's going to pick that, right? They're going to use their coupon. They're going to pay $50 out of pocket instead. And who wouldn't want to select the more fancy sounding brand name when it's actually going to be cheaper? And so the incentives sort of were misaligned there. And there's been this battle back and forth over many years now where employers are looking for ways to respond to this. In some cases, they were implementing what's called copay accumulator programs where they just weren't counting these amounts and the coupon amounts toward the max out of pocket so that patients were actually paying a lot more. And that was a way to defray some of the costs for employers. And then more recently, we've seen another version of these responses by employer plans where they're now deeming the drugs non-essential in certain cases, or even not covering them at all as a way of allowing patients to access more of the manufacturer assistance. So now manufacturers are upset because they're saying, hey, you're abusing our program. You're taking more money than we intended. And so this article describes one of those versions of the program here where they're designating the drug as non-essential. and it's getting the vendor in some trouble here. So Andrew, I don't know if you want to talk about what's happened sort of since involving this strategy and a particular vendor involved in the response by, in this case, Johnson & Johnson.
Right. So this particular vendor program is currently being sued by Johnson & Johnson for, I believe, $100 million. It's not a small amount in dispute. And there are a couple different elements that are being challenged about this program. Similar programs are out there in many different forms, manufacturer assistance / copay assistance programs. There's a lot of different setups that have different challenges and different potential compliance concerns. One of the main things that's being challenged here is the approach that Brady mentioned of deeming certain drugs to be non-essential under the ACA. Why would they bother to do that? It's to get around the caps on cost sharing under the ACA that will apply to essential health benefits. So if you don't do this, an essential health benefit, which includes prescription drugs, you could increase your copays for that drug to be able to hopefully get more assistance from the manufacturer. But once you hit that out-of-pocket maximum, you can't impose any further cost sharing. So you're now paying at 100% regardless. It would basically act as a hard cap on the amount of savings you could create under a program like this. By saying that this specific drug or this specific class of drugs is non-essential, they're basically just saying that we're not going to apply cost sharing caps to these drugs. The copayment, it's going to be $500 per dose, $1,000 per dose, however much they can get from the manufacturer assistance program in perpetuity, just basically with no limitations whatsoever to try to get the maximum amount. And the Johnson & Johnson program is saying that this violates the ACA. There's other arguments about the alleged impropriety of the fee schedule, where the vendor is getting 25% of the savings, amounts recovered, however you want to phrase it. That arguably could be a fiduciary issue. But the main thing is the ACA issue. So there are a lot of different setups here, a lot of different programs aiming at the same goal of trying to extract money from these manufacturer assistance programs, and different approaches have different risks. There's the ACA issue that we just mentioned. Another approach that's gotten very popular more recently is the MERP, MERP, which stands for Medical Expense Reimbursement Plan. And I'm not sure where this approach came from. I suspect some vendor program came up with this and it just exploded in popularity. We're seeing it everywhere, where essentially a plan to try to get assistance from these manufacturer assistance programs, which are generally geared towards uninsured and underinsured patients. They have to show that there's no coverage available for the drug, or that the coverage available is very limited or has a lot of cost sharing applied. An approach is to exclude the drug entirely. The manufacturer assistance program, for example, asks for a plan document to look at the available coverage. You want to be able to show that there is none. But then the risk then is if the patient doesn't get any assistance, they're now left with no coverage for the drug. So what a lot of these programs do is set up something that they call a MERP, which is sort of a separate plan that covers these drugs to pick up that expense on the back end if the patient's unable to get assistance. The problem with this is that MERP is a categorical term. MERP doesn't apply to any specific type of plan setup. So an HRA is a MERP, a full-scale major medical benefit plan is a MERP, and anything in between. Medical expense reimbursement plan is any plan that it reimburses medical expenses. So when we see a MERP tossed around as part of a program, our question is always going to be, what exactly is it? Because MERP doesn't tell you anything. And if a vendor can't give you satisfactory answers to what the MERP actually is, that could be sort of a red flag.
Yeah. I think, Andrew, as I reviewed this article and just like the litigation here involving Johnson & Johnson and the vendor involved, it just shows how really crazy the situation has become with drug pricing, right? I mean, it's really an irrational system that we've got. You have manufacturers that just name their price, and it's true that the price of these drugs is going up exponentially every year. I just sent an article around about a new country's most expensive drug, right? Every few days, it seems like there's a new drug that's supplanting the previous one. It's costing $2.7 million a year, whatever it may be. But the manufacturers name their price and they provide their own discounts in the form of these programs. And then you have these benefit managers kind of scrambling to figure out more and more creative ways to access more and more of these benefits, the discounts that are, and the patient's stuck in the middle. And to your point, what we've seen lately on our side of things is a lot of vendors in this space, are getting potentially themselves in trouble with compliance requirements of the ACA and potentially other applicable laws as well. in trying to, counter the moves by manufacturers. And so this to me is just another example of where it's going to eventually result in government intervention. It's going to have to. And I mean, going back to 2017, we covered a blueprint that was released by the Trump administration that would have tried to address some of these programs. It would have designated PBMs as fiduciaries. I mean, probably a little bit too extreme, but I mean, it was at least some kind of plan to address the craziness going on. There were these, very widely covered hearings on Capitol Hill with the manufacturers, then with the PBMs, because the problem's not going away. And so we're going to track this litigation very closely to see what the courts decide with respect to, this vendor program in particular. Was it actually, in Johnson & Johnson's word, defrauding them of, I think it's $20 million they say that they lost allegedly because of what was used. But obviously what comes out from a court will matter tremendously. But I really do think that we'll need some kind of congressional action here to solve this problem. And until we get that, we're going to continue to see more and more creative programs, right, that pop up, and more administrative costs, frankly, for plans to try and administer those programs to get some relief on these kinds of exploding costs. So any final thoughts from you, Andrew, on what we should see next?
Yeah, so in the meantime, right, until we see a ruling in this case and or some sort of congressional action, what's the takeaway, right? Because plans, they need to do something. They need to be able to do something about these costs. These programs are creating a lot of savings for some plans, but employers need to be really cautious and they need to do their homework. This landscape is a lot more complicated than we see with some other cost containment efforts. An example that comes to mind is drug importation, when that caught on a couple of years ago. A lot of vendors out there doing that, but for the most part, at least more so than here, they're doing largely the same thing. The vendors doing manufacturer assistance programs, we haven't seen two that are set up in exactly the same way. There's a lot of different approaches that carry different compliance risks. So do your homework, reach out to us if you need help understanding a program or the risks that come with it. Hopefully we'll see some good authority kind of creating parameters for what is and isn't allowable eventually.
Absolutely. One can only hope. And so with that, I think we can say Merry Christmas, Happy Holidays to all of our listeners. Hopefully you have a good holiday season. Stay in touch with the FIA Group. We'll be posting more and more content on subjects like this because they're not going away. So on behalf of myself, Andrew Silverio, Pat the Man Santos, our great producer, thanks for tuning in to another edition of the Empowering Plans podcast. And we'll talk to you soon. Thanks.